will be extended. Let's cross there now.
They do have the right of appearance to argue the case to the fullest. And secondly, this is offending to the bar. An attorney who briefs an advocate believes that that advocate is capable and competent to discharge the mandate from the client. Now, for an attorney to force his way to take over the case from an advocate, it means to the general audience here and the court and everybody that this advocate is incompetent and he can't articulate the case of the client competently. But with those brief remarks, my lady, I don't this case is about fair trial, the issues the applicant wants to raise. I don't want another issue of whether there was a fair trial or not to be raised because you refuse to allow Mr. Mthatha to withdraw from the case, and then it becomes another issue. We urge your ladyship to allow Mr. Omar. I'm saying this reluctantly because I've never heard that.
I have not been furnished with any reasons as to why now the change of guard.
I really don't
so
understand.
Far, I have not been furnished as to...
The attorney is, I'm sorry, the attorney is claiming that he is the one who threw the paper. That happens every day. That happens every day. And the appeal I'm having to the court is that for the sake of progress, we would prefer that this unprecedented procedure be followed for the attorney to take over the case and argue.
What so that there is no complaint.
I'm saying reluctantly, so that there is no other complaint. My lady, in this case, the victims are yearning for justice. They want the court to make a decision today. Not this case to be argued bit by bit and until next year. We don't want a situation that we got bogged on non-issues. We want to get right into this case. And again, my lady was indicating reluctantly, if your ladyship could, as you please, you're subject to exercise your discretion, allow Mr. Omar to do what he's going to do, provided. I don't know how he's going to argue.
I don't know what the position is, Mr. Dugata. The problem I'm saying, I'm grappling with is Mr. Mthatha withdrawing, and on what grounds, and is that in accordance with the practice directives of this division?
Yeah, but the other problem, I understand that, but the other problem is that of forcing him to present the case. And there are some problems which crop up there.
Maybe let me get clarity from you, Mr. Mthatha. What is the true position and what are the reasons for your...
My lady, like I said, it is a question of two professionals at different levels doing what is unprecedented.
Why is it so? You were briefed to appear for the applicant today. Is that not so?
That is correct, my lady.
And then in the middle of it, Mr. Omar walked into court, and then you asked that you deliberate with him, that the legal team of the applicant has now been reinforced.
Thank you, my lady.
That is what you said in court.
Yes, and that was the basis upon which an adjournment was sought.
That's right. And now after the adjournment, now you indicate that Mr. Omar will take over the argument in this matter. On what basis?
My lady, as it transpired earlier, it seems that the instructions are not clear whether I should proceed in the matter, because my instructing attorney's view was that we can share the stage to argue the issues. And my view is that we cannot do that. We can only confer. We do not find each other on that point. And I'm withdrawing...
Why the briefing if you cannot find each other?
No, we cannot find each other, my lady, on the manner of approaching the case in court.
But you were briefed by the same attorneys to appear before this court.
Certainly, my lady. My lady, the instructional attorney as a corresponding Mr. Doni, I've been working with Mr. Doni
knowledge of Mr. Omar. Is that not so?
Certainly, my lady. We've been interacting, I've been settling papers sent by Mr. Omar. He drafts
And now why the change of views?
Now the issue is, when time comes for us to address court, Mr. Omar also wants to address court. And I'm saying, my lady,
on what basis, when an advocate has been briefed to appear in court, on what basis has that ever happened in the history of our land?
My lady, I suppose the attorney has the right to brief and withdraw briefs as and when he
is your brief withdrawn? This is exactly what I want to get from you.
This is why, my lady, I'm saying, effectively, because we don't agree on this process, we cannot continue to work.
I don't understand effectively. I just want a straight answer from you, Mr. Matoti. Has your brief been withdrawn? Or not?
May I just take quick instructions on this, because I don't want to mislead court.
I want to get clarity on this one so that I know exactly what to do. Are you still in brief or not?
What my lady we had discussed is that Mr. Omar is going to deal with the matter and I will assist. So my brief is not
assist an advocate, assist an attorney.
That's what I was told, and this is why, my lady, I was saying I would then ask to be excluded, because this is all unprecedented. Ethically speaking, and just to say...
If you were saying your brief is withdrawn, then that would be a different scenario altogether. But for an advocate to be assisting an attorney, having briefed an advocate, it's really new.
Let us take two instructions from both attorneys. Effectively withdrawn.
So you are out of the case?
I'm out of the picture. That's the court process.
Right. Then in that case, Mr. Omar, you can carry on.
Please, my lady.
Do you know what was argued before?
My lady, Advocate Mthatha informed me that your ladyship put certain questions to him which he was required to answer. So with your permission, my lady, I will commence by answering the questions which your ladyship raised to Advocate Mthatha.
Carry on.
My lady, as far as the jurisdiction of this honorable court is concerned, there are two parts to the prayers we are seeking. It's part A and part B.
Part A, is it still viable?
In part A, the applicant seeks a prayer to extend his bail, or the court may add conditions to his continued liberty pending the complete ventilation or implementation of part B. The relief that the applicant seeks today before your lordship is the relief contemplated in part A.
Contemplated in part A?
As your ladyship pleases, yes.
Yes?
My lady, as far as the jurisdiction of this honorable court is concerned, in respect of part A, I respectfully refer your ladyship to section 172 of the South African Constitution.
Yes?
Section 172 of our Constitution, that's Act 108 of 1996, provides the following. When deciding a constitutional matter within its power, a court must declare that any law or conduct that is inconsistent with the Constitution is invalid to the extent of its inconsistency and may make any order that is just and equitable. Section 172, my lady, expanded the jurisdiction of the High Court. Before the enactment of the High Court had the jurisdiction emerging from the common law, more specifically the actu de homine libere.
Mr. Omar, don't make it long. The question that I posed to Mr. Matoti is, two superior courts have pronounced on the validity or otherwise of the conviction of the applicant. The minister has since made his decision known that he has declined the application. Now, what jurisdiction does this court have to even consider or cast aspersions on the decision of the SCA and the CC on the validity or otherwise of the conviction of the applicant?
My lady, the issue that was not adjudicated by the SCA is the issue about the propriety or the lawfulness of Judge Alkema having continued with the trial in the absence of one assessor.
Yes, whilst you are on that point.
I beg your pardon, Madam?
Whilst you are on that point.
Yes.
That was apparent on the very record. You've quoted Alkema J mentioning that one assessor died and therefore could not be able to proceed with the trial. This is an issue that should have been picked up by the SCA. And if there was any irregularity on the proceedings, the SCA would have meromoto raised that. Not so.
My lady, with respect now, the SCA does not have inherent jurisdiction. The SCA is exclusively a court of appeal, my lady. The SCA will only...
But has it not happened in numerous cases that the SCA would raise issues and ask counsel to address it on several issues, on many issues that are picked up from the record?
I argue this very issue in the SCA, my lady. I want to emphasize, unequivocally, if necessary, I'll give your ladyship the authority. The SCA has no inherent jurisdiction. The SCA is an exclusive court of appeal, and the SCA will not adjudicate an issue unless the issue is placed before it. Had the SCA adjudicated on this point mero moto, then the SCA itself would be exceeding its jurisdiction.
Why would it confirm a conviction under irregular, which was, if one accepts your argument that the proceedings were irregularities, why would it confirm so?
My lady, I want to emphasize that the argument, the issue about whether Judge Alkema misdirected himself in continuing with the trial after Mr. Sabula passed away, that issue was never raised and was never argued by King Dalindyebo's former lawyers.
Why was it not so?
Why is it not so? My lady, this issue I expect to say is, did King Dalindyebo waive his right to a fair trial? The answer will be found in the case of Khalfan Khamis Mohammed versus President of the Republic of South Africa. That case was followed by the case of Khalid Rashid that I argued in the Supreme Court of Appeals. The law is as follows with respect, my lady. Number one, a person cannot waive a fundamental right contained in the Constitution. As far as waiver of any other right is concerned, that waiver will only be valid if it is preceded by informed consent. There is no evidence before your ladyship today. There is nothing before the court to rebut the deposition under oath that King Dalindyebo was simply not appraised of the scenario. In fact, when King Dalindyebo's previous lawyers applied for leave to appeal to the Constitutional Court, my officers, I prepared a supplementary affidavit. I forwarded to King Dalindyebo's previous lawyers. They reassured me they will file in the Constitutional Court. I later found out they did not.
Now you're leading evidence from the bar.
My lady,
This is not in the papers, Mr. Omar, and you are not allowed to argue that.
I'm addressing your leadership in my capacity as an officer of this honorable
You are
court.
addressing me as an officer of the court, but you're not allowed to lead evidence from the bar.
Now, my lady, as we are here today, only
I'm
for
asking, why is this taken piecemeal? How does that relate to finality of the judgments of this court?
My lady, in urgent motion proceedings, hearsay evidence is admissible. We are here today.
I'm not going to allow evidence being led from the bar, Mr. Omar. Get clear on that.
As for this, madam.
That is not going to be allowed. You address me only on what is on papers. That's it.
Madam, as far as your leadership's question concerning the Supreme Court of Appeal is concerned, are we making law today? And the law is that if a lawyer representing an accused omits to raise an issue in the Supreme Court of Appeals, and the Supreme Court of Appeals does not deal or adjudicate that issue, then that accused person may languish in prison for about 10 years. When it is known to all that had the issue been raised, I will show you the issue, had that issue been raised, King Dalindyebo's trial would have been declared to have been a misdirection, and the court would well have found that the trial must be pronounced to be a failure of justice. So I respectfully submit, with reference to section 172 of the Constitution, with regard to section 21 of the Superior Courts Act. The Superior Courts Act was enacted in 2013. Section 21, read with section 172, allows for leadership today to have regard to Part B. And when the court deals with Part B, the court will have to issue a declaratory order. And when the court is dealing with a constitutional matter, section 172 unequivocally places the following obligation that is mandated upon the court. When deciding a constitutional matter, is the matter in Part B a constitutional matter? The answer is, it involves a fair trial. Fair trial procedures are contained in section 35 of our Constitution. So, we can accept it is common cause that the issue dealt with in Part B is a constitutional issue.
Is it not inherent in the consideration of an appeal that the question of a fair trial, of an accused being given a fair trial, is that not inherent in the consideration of any appeal?
No, with respect. My lady, in the case of State versus Makwanyana, which I deal with in the affidavit in support of this application, in that case, the Constitutional Court found that because the law does not make any provision for what the position would be if an assessor dies, the Constitutional Court found that the trial against the accused, Mr. Makwanyana, amounted to a misdirection.
You are not answering my question, Mr. Omar. I'm saying, in a consideration of an appeal, is it not inherent to consider whether an accused has been given a fair trial?
My lady, I want
is that not a consideration that comes as a package in a consideration of whether or not the conviction should be confirmed or not?
May I answer that?
Yes.
My lady, I want to emphasize unequivocally. The question is, does the Supreme Court of Appeals have inherent jurisdiction? The answer is a resounding no. The Supreme Court of Appeals is exclusively a court of appeal. It is not a court of first instance. The Supreme Court of Appeal cannot nil motu raise an issue.
It has in many instances that I know of.
My lady?
It has in numerous instances, Mr. Omar, that I know of.
My lady?
Raised issues meromotu and addressed and asked counsel to address them on numerous issues.
My lady?
Maybe you have not come across that.
But
it has on numerous occasions raised issues meromotu.
I came to court thinking that this issue is tough, it's common cause. I will, if necessary, give your leadership authority, and I want to emphasize unequivocally that the Supreme Court of Appeals does not have inherent jurisdiction. The Supreme Court of Appeals cannot nil motu raise an issue that is not argued or placed before it. And what fortifies the submission is that there is not one word in the judgment from the Supreme Court of Appeals dealing with the propriety of the assessor having passed away. There is not one reported judgment in our law today on Section 147 of the Criminal Procedure Act. Section 147 of the Criminal Procedure Act was enacted after the year 2000 in deference to the Constitutional Court judgment in State v. Makonyana. So if the Supreme Court of Appeals did in fact it, I submit, will be clear from its judgment. But I want to emphasize the Supreme Court of Appeal.
I'm not saying it dealt with this matter. I'm saying in a consideration of an appeal, if there was anything amiss, the Supreme Court of Appeal would have raised it. It would not have confirmed a judgment which was obtained irregularly, which was granted when the trial was conducted irregularly.
My lady, with respect, may I speak for you? And moving further. At the same time, I will respectfully say, if the Supreme Court of Appeal was mindful of this issue, the Supreme Court of Appeal would in its judgment have referred to this issue and would have elaborated on the mechanics of Section 147 of the Criminal Procedure Act. So I submit what your ladyship is doing is reinforcing my argument that this issue was not raised at all by the Supreme Court of Appeals. This issue is not raised judicata. This issue is a fresh issue.
But does it mean it was not considered? If it doesn't
it was not considered at all. The only document we can rely upon to determine whether this issue was considered will be the judgment from the Supreme Court of Appeals. And that judgment does not once mention the consequence of Judge Ackerman continuing with the trial with one assessor. As recently as the Oscar Pistorius case, Judge Masipa, when the one assessor was ill, then Judge Masipa discontinued the case and waited until the second assessor.
The difference here now, the one assessor had passed on. He could not continue. This one is distinguishable from the one that you are just quoting. The one assessor had passed on, he therefore was not available to continue with the trial. This is the difference that you miss.
In Art versus Price, my lady, in 1955, the AD is now the Supreme Court of Appeals. I referred to the case in the papers before your election. In 1955, the appellate division in our country followed the English law. The English law case is referred to in the papers before your election. The English law provides that if an assessor passes away, then the court is denied the participation of an important person involved in the fact-finding investigation. And in R versus Price and in English law, the moment an assessor dies, the case has to begin de novo with another assessor. In this case, Judge Ackerman in his judgment alludes to how difficult it was for him to adjudicate this case. The remarks by Judge Ackerman itself reveals that later Judge Ackerman needed a second assessor.
But be that as it may, difficult as it was, he came up with a judgment that has been confirmed by at least 2 superior courts.
My lady, I want to emphasize that the issue about the propriety of Judge Ackerman's...
It's apparent in his judgment that it was difficult to decide with one assessor in the case, but difficult as it was, it's a fact that he has been confirmed, not only by the SCA, but the SCA, the Concord, has also found that there are no prospects of success insofar as the conviction of the applicant is concerned.
Well, lady, with respect, how can we say that this issue was considered by the Supreme Court of Appeals? In its judgment, the Supreme Court of Appeals does not mention at all.
But there are numerous cases to that effect.
No,
the fact that it's not mentioned in the judgment doesn't mean that the court didn't consider. Anderson's being one of them.
The matter was never argued in the Supreme Court of Appeals.
It was never argued, but it doesn't mean that it was never considered. It was apparent in the record, and the Supreme Court, being a court of record, must have seen this, and if there was any irregularity, this would have been raised.
Well, then, with respect, we're going back to my earlier answer to your ladyship's question. The Supreme Court of Appeals does not have inherent jurisdiction. It is common cause that this issue was never raised in the Supreme Court of Appeals. Now, how can we, with respect, infer?
And it was never raised by the applicant himself?
My lady, the applicant's attorneys never raised the issue. Why, I don't know. I have facts which I will present.
Is this not
to
a
the court.
question of the applicant raising issues piecemeal to delay or I don't know, raising issues piecemeal so that finality on this issue is never reached?
My lady, the facts
Would it be unfair to assume so?
Indeed, it would be unfair, my lady. King Dalindyebo has acted hastily at all material times. In fact, at 2 a.m. on the 23rd of December.
Now you are again leading evidence from the bar. I'm asking you to address me. Is it unfair to assume that issues keep being raised on a piecemeal basis here? And finality, this judgment was given 2009, is that not so? It's now 2016, end of 2016, and finality on this issue has not been reached. Why?
Can I deal with your ladyship's questions as it's being asked?
And the record has always been there.
First, your ladyship asked me, would it be unfair to conclude that King Dalindyebo is delaying the proceedings?
Not to conclude, to assume.
To assume. There is no evidence before your ladyship. This is what I find with respect, my lady.
At least the evidence is before me that in the Supreme Court of Appeal, the conviction was challenged. And this is the issue that was considered. And in the Concord, same applies. The conviction was challenged. Both courts pronounced on the validity of the conviction.
My lady tells me with respect, the ladyship does not want to hear that which is not before the court. Is there any evidence under oath before this court today supported by facts suggesting that King Dalindyebo is delaying the finalization of these proceedings? There is none. I'm
not saying he's delaying. I'm saying issues are getting raised on a piecemeal basis, and finality is one of the considerations. Our courts must reach finality.
Raise in the interest of finality, are we going to send King Dalindyebo, a human being who had the right to liberty and a fair trial, to prison? In the interest of finality, I'm saying let's follow the teaching of Ubuntu. Let's persevere. If the issue of finality was so pressing, the state has the resources.
And in doing so, we must also bear in mind what the constitution and the law of this country is. If we follow Ubuntu, but in doing so, the constitution reigns supreme. Not so.
My lady,
and it talks about finality.
King Dalindyebo, my lady, has got a right to a fair trial. The English courts, the Constitutional Court, instead of the High Court, have all found that if a trial is continued in the absence of an assessor who passed away during the trial, that taints the trial unfairness.
Is the unfairness fatal?
My lady?
Is it all the unfairness or the irregularities that happen in our court fatal?
I submit with respect to the did it amount to a fatal irregularity for the trial to continue? Let's look at case law. Let's look at Makanwani, 1995, volume 3, SA 391cc. Let's see what the Constitutional Court says. I, in the papers before the court, quote and convey to your ladyship exhaustively what the Constitutional Court found. Yes, indeed, it does amount to a fatal miscarriage of justice. And this was also said in R versus Price. But let us see. English people in English.
In what way?
I beg pardon, my lady?
It amounted to a fatal irregularity. In what way?
It's tantamount and equivalent to a trial being continued with in the absence of a legal representative without the court advising an accused of his rights to a legal representative.
You say it's tantamount. I'm saying an assessor could not continue with the trial because he was deceased.
Because he was?
He had passed on.
My lady, I'm answering your ladyship's question with reference to decisions from the English court the old appellate division, various high courts, including the Constitutional Court. I mentioned State v. Makonyana in the papers. The Constitutional Court found that the continuation of a trial in the absence of an assessor is fatal to the fairness of the proceedings. This was said in 1955, even before we were ushered into a constitution that has a Bill of Rights. What I'm humbly submitting to your leadership, are we saying that in England, an accused person whose trial is continued with in the absence of an assessor suffers a fatal injustice? Are we saying all the other accused in our country whom the court found suffered fatal injustices because the court continued after one assessor became indisposed, and in other cases I mentioned, after an assessor passed away? So are we going to say there's a different law that's more harsh that should apply to King Dalindyebo, whereas the law vis-a-vis Oscar Pistorius, R. vs. Price, Makonyana, and a host of other people, they get the benefit of having their trial declared a mistrial, whereas King Dalindyebo should not have the same law applied to him. That, with respect, I think, is unfair and unjust and unconstitutional. Let us apply the same law to King Dalindyebo as is applied to English people in England, to R. vs. Price, to Oscar Pistorius, and Mr. Makonyana, and each of the other accused I referred to in my papers before your leadership. What good reason is there why King Dalindyebo should be denied the law being applied to him, whereas the same law on the same issue applied differently to a host of other accused persons? In answering the leadership's question, whether the continuation of the trial in the absence of an assessor who had passed away amounts to a fatal failure of justice, the answer is in the papers. I substantiate my answer in saying it does amount to a fatal injustice with reference to constitutional court authority, foreign jurisdiction, more specifically.
You are repeating yourself, Mr. Omar, and the time is really running. You've been hammering on this point. Carry on.
As your leadership, please. Is there any other question your leadership wishes me to answer before I make my submissions on the application?
We're still deciding on the points in limine.
I'm sorry. Yes,
you missed the proceedings this morning and you don't know what's going on.
No, my lady, I will say I'm sweating. I came here under identifying circumstances, but I'm not explaining it all. I now have the question I have the question your leadership raised. Your leadership raised the following question. How can this court intervene in the light of the minister having made the decision?
Not only the minister, but two superior courts.
And
that has been addressed.
As your leadership, please.
And I don't want any repetition of that.
As well, please.
And then the issue of finality, which has been raised by the state.
So what I propose to do, my lady, is to raise answers or to give answers concerning the decision of the minister and finality. Now, my lady, Section 327 clothes the minister with an executive power. It is a tried principle of our law.
All right, we are, of course, still watching live visuals from the Mthatha High Court. And, of course, that's where Abathembu King Dalindyebo is seeking to have his bail conditions extended. And we are definitely going to go back there as soon as we establish that link. But let's take a quick ad break. You're watching SABC News.